All right, hey everybody, how you guys doing? My name is Adam Rossen, and I will be presenting along with my co-presenter David Terrace on the fundamentals of federal criminal defense. Now, let's talk a little bit about, first of all, who are we? What is our experience, and what are we going to be going over today? So, again, my name is Adam Rossen. I'm the founder and CEO of the Rossen Law Firm, and David Terrace is one of our partner attorneys, and he is the head of our federal and white-collar practice area of within the firm and within the criminal defense portion that we do. Let's talk a little bit about us. We have a very robust federal criminal defense practice that David heads. And we believe in helping good people when bad things happen to them. We're very proud of that. We believe in building relationships with our clients and really going the extra edge. Yes, they're going through a terrible time. Something terrible has happened to them, but it's about the full life cycle of not just the client, but people, right? Before, during, and after. So we really take a strong focus on helping people and making sure that when their case is over, that they can go back to their lives, they can be, happy, healthy, good family, have good families, and just continue to live a great life. That's truly our goal in everything that we do throughout the Rossen Law Firm. Now, introduction, right? Goals for today for this presentation. This is designed for first-timers in federal court and experienced attorneys who need a little bit of a refresher in the nuances of federal criminal defense law. These are things we're not going to be going over things that you would learn necessarily from the books. This isn't going to be a big primer on federal criminal procedure. These are going to be the things that law school doesn't really teach you, that practicing in state court criminal defense, which is completely different than federal criminal defense. It's going to be those things that you won't learn from there as well. So, this is more of a practitioner's guide. You want to know the federal rules of evidence, you want to know the federal rules of criminal procedure, but again, those are things that can be learned from a book. So we're going to be really diving deep. It's not going to be an advanced presentation, but still, diving pretty deep into the nuances, the procedures. If you have a client and you get a federal case, well, what do? Right? That's kind of the point of this, is to really get you folks through that and make sure that you don't just get through it, that you can represent your clients, professionally, ethically, and effectively, because that's why they're coming to you. They need that help. We're also going to be discussing, the differences. What is a federal crime? What makes up a federal crime versus a state crime? We're going to be talking about some different types of, categories of federal crimes, and we're going to be going over the major players in the federal system. Who are the players? Because the players in the federal system, are significantly different than the players in the state court system, and we want to make sure that everybody, that you folks are prepared and know and understand what things are going to look like. Now, here's the overview of our presentation today. I'm going to be walking you through the basics and the client interview portion, and then David's going to be taking on from investigation all the way through post-conviction. Right. Now, let's go back just a little bit, right? From this slide, let's start really talking about, well, what are the basics, right? What is a federal crime? So federal crimes as opposed to state crimes. Usually we're talking about a crime that involves, well, it has to involve a federal code, a United States code violation, or one of the other federal legal codes. Usually we're talking about violations of the law that are carried over multiple states. So examples of that could be wire fraud and drug trafficking. And there's a few different categories of federal criminal, federal crimes. Usually the categories, we have fraud crimes, we have sex crimes, drug crimes. It could be violent crimes, bank robbery, or other robberies under the Hobbs Act, and some other ones. And then again, going a little deeper on the crossing state lines. So what kind of examples of that can we have? One example would be a federal drug trafficking case if the drugs were purchased in Texas and driven to California, or if you left Florida to drive to even Georgia, right, or any other state in order to purchase drugs. It could be something, a violent crime such as kidnapping, a child or a person and taking them out of state. So those are ones where you would, your client would physically move past the border, right? I think those are the easy ones. I think we all can pretty much wrap our head around that. But especially, the last, 10, 20, 30, 40, 50 years, and even beyond, we have a lot of federal cases, especially more and more now with the internet, where your client will never physically cross a state border, but it can still be a federal offense. And so we're, the older cases that still come up, but these ones have been around for years, decades, are examples of anybody who uses the mail, or the the U.S. Postal Service or any mail carrier, could be FedEx or UPS or DHL, any of those, to perpetrate a crime. It could be mailing drugs, right, from one state to another, even though you or your client didn't physically move from state to state. They put something through the Postal Service, illegal narcotics. Nowadays, we have a lot, right? Anything that's done over the phone or internet, especially the internet. That's what we're seeing quite common right now. If you're sending texts and you're soliciting nude photographs from a minor by text, and that minor lives in another state, well, then that could make it federal as well. And in addition, any of the serious financial crimes. So especially now, this is in 2022. We've always had financial crimes, right, with defrauding bank institutions, but the big ones are PPP and now the EIDL, the idle loan fraud. And those are federal as well because it's state lines, it's bank, financial institutions. It could be, Medicare or healthcare fraud. So those are some other examples. Another example could be federal governmental property, right? These are less frequent, but they do happen. So it could be a DUI, which is 99.9% of the time, right, a state court case, but that's a case that happens on federal property, or battery on a federal property. It could be battery even of a VA, of the VA hospital staff, or a VA doctor, or any federal government employee. So those are also examples of what are traditionally and generally, again, 99.9% of the time, those are state court cases, but it could rise to a federal case. And also, there's some cases where, again, general state cases, such as, and one we've been seeing quite often is possession of a firearm by a convicted felon, or felon in possession, and those cases are quite frequently state cases. But at the same time, the federal government can pick those up, can choose to prosecute them if the gun was manufactured out of state, because at some point the gun must have crossed state lines, and it was manufactured there. And so the federal government, we've seen more and more, they've been picking up these cases from the state government to turn it into a federal case. So we've been seeing that quite often recently. And those are, a good broad brushstroke of types of cases that, are federal or, can become federal. So now, who are the major players in the federal system? It's a lot different than state court. So we have the United States District Courts. Usually most of the states are comprised into different, districts within the districts. And we have, there's United States District Judges. They're a lot different than your state court judges, depending on what state you're in. A state court judge can be appointed, can be elected, can be appointed and then elected. But in the United States, federal district courts, they're appointed by the president, they are confirmed by the Senate, and it is a life term. So, talk about job security, right? Once you get to become a federal district court judge, you are set. That is your career, assuming you want to continue in that. And they handle all types of trials within the federal court system. They do civil and criminal. And the same goes with the same goes for the districts. Within the districts, you have the United States attorneys within those districts. Obviously, they will hire assistant United States attorneys, assistant AUSAs, as the primary prosecutors for the federal government within those respective areas within those U.S. district courts. Occasionally, if you have some really complex cases, we may be dealing with a Department of Justice trial attorney. They come down from Main Justice in Washington, and they are, able to handle cases all throughout the country. It's a little, little more rare, but it does happen, especially in the complex healthcare fraud. It happens in terrorism cases, or international money laundering. So usually the larger federal cases are, you have the possibility of dealing with the Department of Justice or a DOJ trial attorney. In addition to the federal district court judges, there are federal magistrate judges, and they're a slight step below. They're not appointed for life. They either serve a 4-year or 8-year term. It'll be a 4-year term if they're part-time. It'll be an 8-year term if they're full-time. They can be reappointed at the completion of their term, and they're basically voted on and appointed by the district court, and then they're basically confirmed by a majority of the judges on the district court. So that does not go to the Senate. It's more of, yes, there's still federal magistrates, but it's usually handled more internally on the local level. I believe David's going to be going into some of the differences between, what the federal magistrate court judges do compared to the federal district court judges. Now, if you practice a lot in state court, this is going to be something that is quite a learning curve or a difference in federal court. In federal court, the courtroom deputy often serves in the traditional function of a judicial assistant. The federal judges, they have their own judicial assistants, but the courtroom deputy is really the one that's, for all intents and purposes, running the show. So it's a lot different than state court, where traditionally the judicial assistant is running all things such as the calendar and scheduling and courtroom decorum, and then the deputies are just there to make sure that all the parties are safe. So you're going to really want to know who your courtroom deputies are, and really make sure that they are the go-to for you for whatever federal case you have in front of each judge. Now, understand that there's like all types of court systems, there's local rules, and there's judicial guides and divisional instructions. So always defer to those. That's a great place to start for the new practitioner, right? To just kind of again get a lay of the land. What are their names? What are their phone numbers? How do I get in touch with them? Who's doing what? So you want to know that. Additionally, the U.S. Marshals Service, they're the ones, the federal marshals, they're the ones who are the traditional state court, or function as the traditional state court deputies. And then you have, the United States Pretrial Services and Probation. They're the ones who run, if your state court has pretrial or probation, they're the ones who pretty much run that, especially with the pretrial services with the clients. So that's going to be somebody, or the other division. So those are really the parties in the federal system. You need to familiarize yourself with the players. You need to come prepared. Federal court, especially federal criminal court, is completely different than state court in the aura. It is very austere. It is, grandiose. It is slow paced. There is no feeling of cattle calls that you may feel in state court with a packed courtroom of 100 people. You really can't just walk in there and wing it. You need to be prepared. You need to do some recon. I can tell you, 15 years ago when I started the firm and was just learning this, and luckily or unluckily, we didn't have many clients right away. So what did I do? Well, I just went into the federal courthouse and just sat around and watched and asked questions. Obviously I didn't have any cases on the docket, so I just sat and watched. I read the divisional instructions. I talked to older attorneys that had been there to try to get that information. It's really important to be comfortable with that. And if you have the time, what better way to learn is to just go be a fly on the wall and just start talking to people and asking questions. That's highly recommended. Now, as we're going on to the client interview, right? I always like to joke, the basic questions: who, what, where, when, why, how, right? But oftentimes we forget this. And who, what, where, when, why, how, these are the basics of any communication, of any interview. But sometimes we're lost on the fact that the main purpose of any client interview is to build trust. Okay, something is going on in a client's life. I see we have a question. We have a question. I'll answer that now. So divisional instructions. So a lot of the judges, if you go onto their judicial webpage, it will have their instructions for how they like things to be handled. Quite often they have certain rules, or even within the local rules, the judges will have certain rules regarding the way they like their motions filed, the way courtroom time starts, the way that they like their decorum. They may want AUSAs and the defense counsel to speak about certain topics prior to court, or make sure that you're extremely prepared. So there's a lot of different things that are in the divisional instructions, and I've always found that it's key to really get your insight into the judge, because you certainly don't want to show up to court, start talking about something, and then have a United States Federal District Court judge say, well, counselor, that's clearly against my judicial or my divisional instructions. Did you bother to read that? And then already you're starting off on the wrong foot. And who is that going to hurt? Who could that potentially hurt? Right, your client. So all you have to do is just go on Google and search, depending on your jurisdiction, and most jurisdictions have that, and we found that to be very important, especially for newer practitioners. And that's a great question. Thank you for that. Going back to the client interview, right? The most important thing, I believe, is building trust. You have a client who is scared and nervous. They can be at many stages of the case or of an investigation, but regardless, some intervening life event has happened to bring them to your office. You must build trust. That is the number one thing you must do in any client interview. Okay, when you're meeting with clients, it's a very fluid situation, because yes, you have to build that trust. You have to get them to open up to you, but you need to find out at what stage in the case they're at. And in the federal system, the stages can be, there's more stages, and they can be more complex than state court. State court is usually, has the person been arrested or not? If they had, well, then that's easy. They've been arrested. And if they're out of jail and bonded out already, that's easy. They're in front of you. If they're still in jail, then you're most likely meeting with a family member. If they have not been arrested yet, then there's an investigation, right? But in the federal system, the investigation process is a lot more complicated in and of itself. You need to find out, right? Have they been questioned by law enforcement? Have they received a notice from the government that they're under investigation? The federal system is quite different than state. In fact, that quite often they'll actually send you a letter Are they a target, or are they, a suspect? There's a very big difference between those two. So, and the government will literally, not always, but quite often, they'll send you a letter, which, in state court, at least in South Florida, is, unheard of, for them to just send you a letter saying, hey, we believe you've committed a crime, right? Or you're under investigation. So you really need to find that out. And quite often people don't really fully understand the process. So you have to dig deep with them, because we've had clients call us and come in and say, look, I received a phone call saying I was the victim of fraud or the victim of a crime by an FBI agent, by the federal government. And when we peel it back, we find out that no, actually they could be a co-conspirator, they could be a target, they could be a suspect. So this client interview process is is crucial, right? So we're talking about now who, right? So has the client been contacted by law enforcement, and which branch of the Department of Justice? There's the FBI, the DEA, ATF, right? Alcohol, tobacco, firearms, Department of Homeland Security, DHS, Secret Service, and the IRS. You can go to justice.gov to look up the different branches and really find out more about what they do and what they specialize in. I remember being, very young, even back when I was a prosecutor before I left, I had no idea at that time that the Secret Service, also dealt with identity theft, right? I'm like, why would the Secret Service be on this case? It's not involving the president or a high-ranking member, a politician. And then I found out, oh no, they actually are very involved, with investigating identity theft and fraud cases. So you really need to get to know the players and really have the contact information at your disposal, because you always want to be prepared and be prepared, fully prepared before a situation happens. So before the client calls you, before the client and or their family come in to meet with you, you want to make sure that you have a list of all the contact information of the federal law enforcement in your area, so that way you can have that, you can discuss that with the client, and you're not scrambling to find that later. We believe that's very important, with making sure that you know who the players are. Secret Service is a little more specialized, but FBI, right? The FBI has many different functions, and so quite often a client will say, well, I'm being investigated by the Fed, so it must be the FBI, right? But it could be the United States, Postal Service, right? It could be a Postal Service, federal inspector for the Postal Service if we're talking about mailing a package that had narcotics in it. And you got to ask those detailed questions to really get at the heart of it. So you never want to take what a client or potential client says 100% with a grain, or as 100% true. Not because they're being untruthful, but because they just don't understand and know how the whole system works. So they might say, well, yes, I got contacted by, the FBI, but it might be the DEA, it might be somebody else. And they're just putting, their spin on it because they don't fully understand. So never, ever, ever take what a client says to you as far as who contacted them and when and why as the gospel. You always want to ask those questions. And again, it's who, what, where, when, why, how. It's, just go back to the very basics, but go deep. You want to go deep with your client. Now we're talking, about how, right? When did they first become aware? Sometimes clients will get a call or a voicemail with, that's generic, but it says that there's an issue and they need to call, the federal law enforcement. Well, a lot of those sound like scams. So sometimes clients aren't able to differentiate most of the time between what's a scam and what's actually the truth. So you need to ask these questions and find out, have they had any calls? Did they ignore them? Did they not? Is that the reason they're here? or were they engaged in any follow-up? Right? It could be, a target letter through a federal prosecutor. It could be, again, a federal law enforcement. Sometimes they do show up at your house. I know, that's usually the way they do it in state court. Federal court, there's many different ways, but they do that, in the federal system as well, where they could just show up unannounced. Obviously, it could be a search warrant or some other, right, warrant your home, your business, a vehicle, or it could even be a grand jury subpoena. Basically giving you, X amount of time to show up in front of the grand jury with documents. We've had situations where a client will show up to their bank to make a withdrawal, and the bank, they'll call the bank manager who says, "I'm sorry, but we can't give you access to this." Some bank employees are a little more forthcoming with why, but we've had clients that, just they don't understand what's going on, and they find out that their bank account's been frozen. And finding those things out will give you a better idea of where within the investigation your client is. That's really important, is to find out where within, the investigation, because these investigations can go on for quite some time, and there's many layers to federal investigations. Unlike state investigations, for the most part, they're faster. There's not as many, people involved. There's not as many players, especially in Florida, where we're based out of. They don't use the grand jury that often, unless it's usually, especially in South Florida, unless it's murder cases or high-profile cases. Most of the time, the prosecutors will file charges by information in state court. So the federal system, uses the grand juries, a lot more than generally state courts, at least in South Florida. And even with, a package, right? You may get that notification from U.S. Postal Service that, hey, the package that you were expecting has been seized, with a phone number to call about your package. So there, you want to go deep. So once you've built that relationship with your client, and you've starting to build that trust, you need to know, right? Was this one phone call? Was it one voicemail? Was it going on for weeks? Did they ignore 3 letters, right, from the government? How long in between those contacts? Did they hear anything from friends, family members, people who may end up becoming co-conspirators? Is there chatter about something that they may or may not have done, right? You really need to go through and go in the nitty gritty with that. Now, we're going to go through to why, right? Okay, you want to know, right, why? And a lot of people will come in very guarded. They're going to kind of, again, it goes back to the trust. So you have to build that trust. You have to kind of get them comfortable, get them to be a little bit disarmed, really ask these questions, because deep down they know, most of the time, they have a suspicion, they have a hunch. When that intervening event has occurred, all they do is they think about it, they obsess about it. That takes them to pick up the phone, to call you, to schedule an appointment to come into your office. So you're going to really need to go deep with the why. You want to know where, right? Where did this take place? We want to know the players. We want to get, the other people that they've, have dealt with. Is this another county? Is it another state, right? Where were the dealings done? Over the phone, text, or email? These are all different things, because you want to know. You may have a case where they might live in the Southern District of Florida, but that client is actually being investigated in one of the districts, the district courts in Tennessee for a crime, yet that client lives in Florida. So you need to get that information, because, you as the attorney, you want to be the source of knowledge, and really that's going to steer, what you do, what your actions are moving forward, right? Again, we want to know, when did the client first become aware? What documents do they have? Do they have anything, right? The financial crimes, there should be some documents. You're going to want to make sure that the client can provide you your documents. Your client is a major player in this as well, right? We've talked about the major players, and I didn't even talk about your client. Your client is going to be a great source of information. Again, not so much information at first. Well, I got called from the Fed, but as far as an information for you as the attorney to figure out the next steps to gain information, and come up with a game plan of what we're dealing with, because you don't want to walk into a phone call with a special agent or with an AUSA and not know anything. You might want to, depending on your strategy, not divulge a lot, and let them talk, but you don't want to know nothing. You want to come into that phone call, that initial contact with law enforcement, prepared. Okay, and obviously, did they speak already? What else has been going on with them throughout this case? Because the earlier you get involved, usually the better it is. But people tend to contact attorneys at all different parts of the investigation. We've pretty much seen it all. Now, question that we get quite often is, should you talk about sentencing exposure during the initial client interview? I believe you should. We believe you should, not from a position of scaring clients that some attorneys do, scare them into hiring you. Not from a position of weakness either, because when you're meeting your client, again, you have to build trust and confidence, but from a position of knowledge, right? You need to give your clients knowledge about what they're looking at and what the process is going to be like. This, for most clients in the federal system, they've never walked down this path before, but even if they have, maybe once, right, before, you are not just their fierce advocate, their fighter, their shield, but you're also the wise old sage who is their tour guide, right? You've walked these shoes 10, 20, 50, 100, 1,000 times before. So you can tell them where the potential issues are, the minefields, the things to be looking out for. And exposure is part of it. Based on federal guidelines and based on things you may have seen before. You never want to just come into a client meeting and go, yes, you're screwed, so I'm just gonna, plea you out, and we're talking how much prison here, even though we know that the federal, conviction rate is very high. Over 95% of federal cases, don't go to trial, right? And they have a very high conviction rate, some kind of criminal sentence. But you want to be open and honest. You want to be upfront with the client. Again, it's about building that relationship and letting them know all of the things that go into your mind as far as how to successfully defend somebody accused of a federal crime. So my personal recommendation is, we do it. I think it's very successful. We don't want to shy away from it, but we don't want to be doom and gloom either. So you have to be realistic. It's the same thing, I think, with any client in state court. You want to talk about minimum, maximum penalties. It's just, kind of the way we do it and what we believe in. Now we're going to transition over to David for for some more nuts and bolts, and we'll go deeper dive within the investigative pieces.
Thank you, Adam. I appreciate it. That was a great introduction. Thank you for introducing me, and hello, everybody. So again, I'm David Terrace. I'm the head of our Federal Criminal Defense practice here, and it's my passion. It's what I've always wanted to do. It can be daunting, but it can be done, and it can be done earlier in your career if you're able to get the guidelines down and to take some risks. So we're going to talk about that. And this presentation, Adam kind of touched on it before. It's going to be very much a practitioner's guide. We're going to spend time on a lot of concepts that if you've been practicing in state court, if you are a criminal defense attorney, a public defender, or in private counsel, but haven't been in federal, then you're really not going to see so much of this. And it's things that I probably wish I would have known when I first jumped right into federal practice. trial, or Adam went through the overview, trial process, filing motions. Some nuances there with federal court. Mostly it's knowing knowing the judge, knowing the prosecutor, knowing what they like, and following the local rules and procedures. But it's the investigation stage, some of these things that are not written down anywhere that we're really going to focus on. So starting with investigation, of course, if a client comes to you and they've already been arrested or they've already been charged, and a lot of this might be superfluous, but we do get a lot of clients who come to us during the investigation stage because of how the federal system works. It's built on, very often, not built on state court where you see a crime committed and you're arrested and you have first appearance the next day. Federal law enforcement and Department of Justice, a lot of times they take their time, and we want to get in as early as possible. Investigation is actually one of the areas where the defense attorney can probably do the most good, believe it or not, and we'll talk about that. So it starts with the client interview. As Adam said, we're not interrogating the client, but we really do have to gather as much detail as possible at that stage, at the client interview, because timetable, we don't know where it's going to be. Are we 2 years out from an indictment or an information? And we'll talk about the differences later on. Are we a week out? Are we a day out? We just don't know. So we have to build as much as possible. It's not like in state court where client comes to hire you and they said, yes, I was arrested yesterday. And you say, okay, I'll have a probable cause affidavit pretty soon online. Not very, very rarely does it ever work like that. So after the client interview, after you've determined and you've gathered as much information and you've built that trust with your client, next step is reach out to the prosecutor or don't reach out. And 99% of the time, the right thing to do is reach out. And so we'll definitely talk about that. So a lot of goals in the investigation stage, or sometimes we call it the pre-filing stage or pre-arrest stage. Your goal is really to be a sponge. So when you're having that initial contact with law enforcement, either the agent who's investigating or if there's a prosecutor assigned to the case, we'll talk about the differences between those two concepts and similarities as well. You just need to gather as much knowledge as possible. Just like you're doing in the client interview, you're kind of interviewing the prosecutor and the agent as well. You want to learn as much as you can about the case from the client when you meet with them, but then when you go and talk to the prosecutor, something that I do, a practice tip very often is sometimes reaching out and saying, hey, I don't know anything about this. Just I gotta advocate for my client. We got to make some big decisions here. Please just tell me as much as possible, because sometimes a prosecutor or an agent in the federal system will keep it close to the chest for several reasons that we'll discuss. So there's different creative and tactful ways of squeezing information in the investigation stage. So you want to get as much information as possible, and you want to be able to set your client's expectations. I mean, any state, federal, any criminal defense practice, managing and setting expectations as much as you can. We don't have a crystal ball, but as much as you can is super important. Are they potentially going to be indicted in a week, a month? Do they want to have a sit down with our client? Do they want our client to cooperate with the federal government against somebody else? All things that we'll discuss, but we have to really figure out what the government's intention is prior to filing charges the best we can. And then, of course, the ultimate goal, which is difficult but can be done, is to dissuade the government from concluding their investigation with a criminal charge, an arrest, and then a charge against our client. It's possible, and we'll talk about some of the ways, and it's very dependent on how soon the client comes to you and where the government is in their own timetable. So how do we achieve these goals? First, just shielding our client, being our client's voice, reaching out to the prosecutor and saying, our client is invoking their right to remain silent, but we'd be happy to speak with you and facilitate your investigation in any way possible. But please stop calling my client. A client has a right, as we know, under the Fifth Amendment to remain silent, and they have a right under the Sixth Amendment to have, and 14th, to have counsel represent them and to be their voice, speak on their behalf, and to be present whenever they are questioned by law enforcement. And federal government and federal criminal defense, more than dealing with state prosecutors and law enforcement, are much more receptive to hearing from attorneys during the investigation stage, because the federal government, your client might be at the very top of the food chain, so to speak. Your client might be the primary or the conspirator in a scheme, or he might be the only person they're looking at for a specific crime, but they're always in the back of their mind trying to find the big fish. So we definitely want to be that voice for our client and present those opportunities. Asking the essential questions early on, same kind of questions that we ask our client: the who, what, where, when, why, and how. Finding out what agency it is, what crime are they investigating or crimes, where do the alleged activity take place. These are questions that we try to get from our client. Now we're going to try and get it directly from the one who's making these decisions. Where is really important. Sometimes we have a case that is being investigated. All the prosecutors, the Department of Justice trial attorneys, and the Human Health Services and Medicare investigators are based out of Texas, but the investigation is happening in South Florida. And we're trying to figure out, is this case going to be filed in Texas? Is it going to be filed in South Florida? We're based in South Florida, but we do have cases all throughout the country, federal cases. So where is super important. When did the alleged activity occurred? That's very important. Also, when can they give us any kind of timetable as to when they're planning on proceeding to whatever their next step in their investigation might be. That's, if you really can't get much else, just being able to tell your client you have a month before they intend to make a decision about a grand jury, you have a week, you have a day, or they're years away. That's super important to know, and to help manage your client and to build that trust as well. So the next thing, why my client, and this concept of witness, subject, or target, we're going to talk about in detail, but it's probably the most important concept of an investigation. Why are you investigating my client? Simple as that, but it's also very, very nuanced and complex. And of course, how is finding out. This takes time. It's not going to happen on the first phone call with the prosecutor or the second. If they intend to bring charges against your client, or they're investigating your client for a crime, as opposed to potentially them just being a witness to a crime, or even a subject, and we'll talk about the distinctions, are there ways that we can resolve this without criminal charges being brought? So we talked about the invocation of rights, right to remain silent and right to counsel. If for nothing else, we're our client's shield and their voice. So we've said that. So if there's probably one thing, if you only had one option, government said you can do one thing during the investigation stage, Mr. Terrace, what's it going to be? I'm going to invoke my client's right to counsel and their right to remain silent. I did include in here common and good language for an invocation of rights. So you can rely on that, and you'll have the materials if you'd like. But this is a pretty all-encompassing example of an invocation of rights. So witness, subject, or target. This is a really, maybe the most important aspect as far as fact finding and determining where your client is headed, where you're headed with your client in the federal criminal process. There's a lot of reasons why we want to know this. Just one of these, even just this one word, witness, subject, target, this moniker tells us so much about the nature of the government's investigation. So we want as much clarity as we can get here as possible. It really determines what the next weeks, months, years of your client's life could potentially look like, and your own practice as well, and what your next steps have to be. So this is like a very first question, I would say, maybe after timetable. When are you planning on moving forward with charges against my client? If you are, probably the next is, are they a witness, subject, or target? And it is so important, really, because it has a direct correlation to the likelihood that they will be either arrested or later charged with a crime, as well as the timetable of that. If somebody is a target, that means that the government has already established they're pretty far ahead if they've already determined. Just practice tip, I ask the prosecutor directly if they don't say it on the phone, or if it's a law enforcement agent you're speaking with. I'll say, one of my first questions, is my client a witness, subject, which is how in the federal system kind of a suspect, what's referred to as subject, or target. So of course, at the one end, we have a witness. If your client, and many of our clients who come to us fall into the witness category, because you can be contacted by a federal agent, and they might just say, we'd like to speak to you about so-and-so scheme, about this Ponzi scheme. And you client might know, they might that they're just a witness to it. They might not know, because it is a legal distinction that's specifically defined. And there's also we have witness, people mostly think someone who has seen a crime occur, but in the federal system, it has specific terminology attached to it. And it also means a lot as far as we're talking about, why is this knowing where our client stands on this spectrum so important, is because one of the next things we're going to be talking about is what's the best way to, and how can we successfully keep our client from being charged. And we do that by keeping them from on the low end of this spectrum, ideally a witness or a subject, even if they are a target, keeping them one that might be able to, we might be able to get them successfully changed in the mind of the government, whether they'll classify it as an actual change or not, from going to a target to a subject. And that's, we have had a lot of success with that, and it's a definite goal for any representation during the investigative stage. So for a witness, it doesn't necessarily mean that you saw a crime happen. It could be that you know information about someone else that they're investigating, or that you've potentially also been the victim, kind of falls into witness as well. And they might not know that yet. The government might not know that yet. Your client might not know that yet. But even if you get a call, and if you're in federal criminal defense and taking on clients, and the client calls and they say, I got a call from somebody from the Office of Inspector General, the FBI, and they said, I'm just a witness, so they'd like to talk to me, and I don't really need a lawyer, do I? Absolutely, absolutely. Because one, the government and the agents are allowed to tell you you're a witness, with rare exceptions when you're not, when they believe you do know more, to entice you to speak to them. And it can definitely, at any point, it can change. You can go from a witness to a subject to a target, depending on that conversation that you have. And we have clients who come to us all the time that said, hey, they told me I was just a witness, so I went and spoke with them. And sometimes they can be subject, as we say here, to obstruction of justice or lying if they weren't completely truthful during that interview, even if they were a witness. Now they're something more, or they really had more criminal exposure than they thought they did. And these agents are usually very well trained at making people feel like they're just witnesses or maybe just subjects, because that's how you get them talking. Less people are going to ask for an attorney or say, I'd prefer to remain silent right now if you tell them they're a witness as opposed to a target. So don't assume that just because a client says they're a witness that there's not more. You have to dig. You have to go further. So continuing, okay, on the other side of witness is target. And when a prosecutor or deems, with the help of law enforcement together, when they deem that somebody has been as a target, it means that they have substantial evidence already that that person has committed a crime. So when we're talking about timetable, like why it's so important, you can imagine that if prosecutor says your client's a target, especially if it's a financial crime, a white collar crime, or some sort of ongoing or long-term conspiracy, maybe over a period of months or years, that means that the government has been investigating them for some time. Sometimes that the government, whether it's the prosecutor or the investigator you're speaking to, if they say we haven't quite determined where your client is yet, well, one thing, it's a good thing to know or ask colleagues about the prosecutor, because they're not always as genuine as we want them to be. But that also tells us that they're earlier in their investigation. If they have targets already listed out, then we know that they're pretty far along, and we have to really, really get working. Subject is in between. So to federal prosecutors, to the Department of Justice, a subject is a person whose conduct is within the scope of a grand jury's investigation, meaning that they have relevant information. They could be suspicious. They do have some criminal exposure, but not enough for the prosecutor to be able right then and there to charge them or to ask or present to a grand jury information to charge them. They're digging more. And what we really want to do in that situation is go keep them or try and get them from subject down to witness, or from ever becoming a target. And we'll talk about some ways that we can do that. The DOJ Justice Manual is a really great resource. I have the link at the bottom there. If you go to the DOJ site, it's pretty much what their internal directives are, and it's all public. And it defines these terms very well, so you can speak intelligently, your first day on the job, so to speak. According to the DOJ, a target is a person to whom the prosecutor or the grand jury has substantial evidence linking him to a crime, or in the judgment of a prosecutor is a putative defendant, basically that they're going to be brought in as part of a conspiracy, even if they're not the main individual that the government's ultimately targeting. The subject of an investigation is defined as a person whose conduct is within the scope of a grand jury's investigation, but they don't necessarily have substantial evidence just yet. So you want to do your homework, and you want to do it quickly, because you want to keep your client, if you get hired in the investigation stage and hired early enough, from ever getting to that target point. Can't always happen. Sometimes your client comes to you as a target, just like sometimes they come to you halfway through your case, and you just have to be able to adapt. So as I said, status can change. Don't get comfortable. Don't get complacent. Make sure that you are not, if you get a call or the prosecutor says your client's just a witness, don't just say thank you. Let us know. And sometimes there can be certain incentives to not create a situation where there isn't one, but don't promise your client something that you don't have actual factual information on. Still dig and still find out how can you get your client out of this. We don't want them being involved with the federal government. One way we'll talk about when we get to proffers in a bit is especially when your client's a witness or a subject, is being the first in, first out. That's what I say. First in, first out. And prosecutors often say that too. They'll call a client and the client will say to us, well, the investigator or the agent said, hey, if I come in first, then I'm going to be best. And that's very often the case. Certainly for witnesses and certainly for suspects and potentially even targets as well. If you want to go in and you want to have what we're going to talk about as a proffer or cooperation session with the government prior to them bringing charges, you want to be the first one there because they will not tell us. If we have a session with them and they ask about some other individuals, then we might learn. But a lot of times they will not tell you who else they've spoken to because investigation is not public record. So you have to assume that they are talking to other people, and we don't know what that other person they're talking to is going to say about our client. I've definitely had cases where I had to sit down with the agents and the prosecutor, and they said, David, we have already kind of an idea that your client was really just a witness or had some involvement, but wasn't a leader of this conspiracy or anything along those lines. But several other people are saying that he was. So again, that's why you can't get complacent and you have to act quickly when we're dealing with the investigation stage of a case. Again, major goal, getting in as early as possible before they've classified or made any ultimate decisions regarding your client. In reality, this might be out of our control. They might have already made up their mind. They might have had 10 other people come in and provide information, and they've built their case over a period of years, and there's no avoiding it. And then you just have to act accordingly. But you have to try. You can't just sit around in the federal system and wait for the arrest or wait for the probable cause affidavit. There's a lot that can be changed at this stage. I say at the bottom here, but I'll just finish here. Your client might have already come in, and Adam mentioned this. They might have already received a target letter, so we know that they're a target. They might already have received a subpoena to testify or provide information to a grand jury, which would suggest that they are more likely a suspect. Again, every case is different. Search warrant could be either. But some of these things might have already happened. We don't get to choose when our clients come to us for their help. I'm going to now be sharing my screen. So this is an example of what a target letter looks like, which is very common in our federal cases. Pardon my terrible redacting, but of course it must be done. But this is a case that we have. So client will. They don't all look like this, but client will receive a letter. Top, it says read federal grand jury investigation. And this letter is to notify you that you are a target of a federal grand jury investigation in the Southern District of Florida involving possible violations of federal criminal law, involves limited to conspiracy to commit wire fraud, bank fraud, and one of the ways that even if you didn't know, a good tip is, let's say you didn't receive a target letter, but your client tells you, or you learn, or the agent or the prosecutor says, your client, we advise that your client bring counsel or have counsel, or we can appoint counsel. That means you're a target because you don't have a right, and it's a case called Castigar that we'll talk about, but your right to counsel when it comes to grand juries and whether you can be compelled to testify or not really kicks in when you're a target. That's kind of getting a little technical and more than fundamental, but I wanted to show you what one of these looks like. You can see at the bottom, it says, if your counsel does not contact me or you do not contact investigator Matthew Isman regarding appointment of counsel, I will assume you have elected not to resolve this matter at this time. In that event, the grand jury will consider the facts obtained during the course of this investigation. So again, this is what we're talking about when we say if somebody's already been designated a target, things could be moving pretty quickly. And that shows us that. And that's why we want to find that out as soon as possible, because not every target receives a letter. They don't have to send a letter, actually, unless they intend to try and compel your client to target in a grand jury. They really can't. Our clients would just take the fifth anyways. And another practice tip, this 14 days of receipt of this letter, very often the prosecutors are flexing their muscle when it comes to we have a grand jury lined up. Get on the phone with the prosecutor as soon as possible. And here they're saying contact the investigator, Matthew Isman. If there's a prosecutor involved, the investigator will direct you straight to have those kind of conversations with the prosecutor. I also wanted to show you here an example of a grand jury subpoena, now. This was a case that was out of Massachusetts, but our client was in West Palm Beach. And some of the differences is you're commanded to appear in United States courthouse at this time to testify below the court's grand jury, or to, here it says, provide documentation. In lieu of a personal appearance, records may be produced on or before the date and time. If you have any questions, please contact the prosecutor. And then the prosecutor's information is down there. So more often than not, if your client comes to you having received a subpoena to testify or provide documentation, you can assume that it's not good to assume, but you can predict once you have the expertise and the comfortability to do so, that they're a witness or a suspect. Witnesses usually get less threatening subpoenas, or they're just called by an investigator. So again, federal government has a lot of tools at their disposal when it comes to an investigation that you have to know about and be prepared to deal with. Wiretapping, physical surveillance, monitoring online activity, controlled calls, or when they're having somebody who's cooperating with the government make a phone call and on a special phone and the government's on the other line, or it's being recorded. Subpoenaing bank records and financial documents, very common. Issuing grand jury subpoenas, which we talked about. Search warrants, very similar to if you've dealt with search warrants in state courts. There's not much difference there, other than the search warrants might be a lot more complex in a federal investigation. And conducting witness interviews and proffer sessions. So this, when we're talking about how do we achieve our goals in the investigation stage, is really a great time to transition into this very, very important concept in federal criminal defense, which is the concept of a proffer or cooperation. And it's not something that is very rare in state court. And it's an art, really. It takes a lot of practice, and it's good to speak to experienced attorneys about proffers, because they're some of the most crucial aspects of a federal criminal case. So to proffer or not to proffer. And we'll talk about casting our letter and the protections that you get. So more or less, a proffer in the context of, well, proffer is a word that's used, defined, I guess, would be to provide something to someone, or to provide information. So in the federal criminal defense context, it's one of the biggest aspects of our job. It's a offer for our clients to provide information and cooperate with the government, usually in exchange for some sort of benefit at sentencing, and potentially no charges whatsoever. And that also depends a lot on where they are on that spectrum. Sometimes it's the only way to really gather the information that you need It can be used as an investigatory tool by the defense, but you have to be very careful doing it that way because the government is not as smart as they seem, but they are smart. You might also hear this proffer referred to as a queen for the day agreement. Sometimes it's also called a debrief. And the best time to do it is early if you're going to do it, and we'll talk about why, but it could come at various stages, even once a prosecution has already started. So usually the U.S. Attorney's Office or Department of Justice Criminal Trial Division is investigating someone, and if they either think that your client has information that would be valuable for them to know, or if you learn that your client, from building that trust with your client, that they have valuable information, you want to set up a proffer session. Maybe other lawyers are different about this. I try and set up at least an initial meeting proffer session in every single case I have, even if it's very clear that the client, the case is just about them. If they forged a passport, maybe, and you'd think, well, what do they have to know? You never know. You never know. And sometimes prosecutors don't always think about it, about the possibility that your client has information. It's a tough concept to breach with the client, depending on the case, because a lot of clients refer to this as snitching. In state court, it's not very common. It's not always necessary. Pretty usually more cut and dry. This is the allegation. You have some wider investigations and conspiracies in state court, but especially in white collar and fraud cases in the federal system, organized crime cases, drug trafficking cases, and that's where things get a bit more dicey. You really want to have a heart-to-heart, so to speak, with your client about what they know. And sometimes that takes time. You have to build that trust. So they can happen, the actual meeting can take a lot of different forms. It can happen usually at the U.S. Attorney's Office. Sometimes it will happen at the FBI headquarters, wherever that might be in your district. And sometimes it happens at my office, at the attorney's office. Just depends on the circumstances of the individual case, and also how much protection, because these are under seal until they're not later, when sometimes they have to be disclosed, which we'll talk about. But your client is providing information, they're cooperating for a benefit. So I guess big question, why proffer? Why go out of your way to provide this information? How will it help me, and how will I be protected? Because in a proffer session, the very first thing, and you go in with your client, and let me stop there. Before you go in, you want to have prepared extensively with your client for this session for several reasons. You're trying to have your client give the most benefit possible, possibly be able to avoid charges altogether. If the client or the attorney, and sometimes called an attorney proffer, you can go without your client, present information on behalf of the client, or the client presents information to show that they're not as culpable as the government thinks. They're not actually a target, they're a witness, or they're a suspect. But every single proffer session begins with what I basically call the truth serum phase. It's an audition. You go in and you sit down, and usually it's the defense attorney, our client, at least one agent, usually more investigators and agents, and at least one prosecutor, and sometimes more, depending on the nature of the information that's being sought. And the first meeting, and this is something that is really, these are the kind of tricks of the trade that I think a CLE like this is so important about. The first meeting, or at least the beginning of the first meeting, is a truth serum. It's an audition to see if the government would even want to potentially use your client as a cooperator against a co-defendant, providing information that leads to other arrests and investigations in general. And so what they do when they start off, and again, my primary practice is in the Southern District of Florida, but I've had cases around the country, and pretty much standard across the board is they will ask questions, sometimes for the entire first session, which seems like a waste of time, but they have their reasons that they already know the answer to. So when you're preparing your client for a proffer session and you're deciding whether or not we should go in and cooperate, there's a lot of things to take into account. Most effective thing that I do, and that other lawyers who are my mentors and great federal defense attorneys will say, and that you should always tell your client before a proffer session, is if you go into the session and you want to provide information, and it's voluntary, they're not compelled, it's not under a subpoena, it's voluntary to try and help yourself by helping the government, is to assume that every single question that is asked of you, every single question that the government asks your client, tell your client to assume, presume, and just on the word of God, the government already has the answer to the question. Because if you can get that concept across to your client and they believe in it and they trust you and they can follow that, then there is no possibility that they will lie to the government. There's no possibility they will omit or exaggerate or minimize. You just answer the question that was asked, nothing more, nothing less, just what was asked, and just assume they already know the answer, because they usually do. And even if they don't, if you assume that they do, then you won't lie. And we're going to talk about why it's so important that you don't lie, other than obviously it's not good to lie to a federal agent, because there's specific consequences if you decide to proffer. Usually the first time, if you pass the audition and then you want a goal is to have a second, a third proffer, maybe if your strategy in a case is for your client to cooperate for their benefit. The attorney does play a large role in the proffer as well. Most of it is us sitting and listening, but a very important part is a very high intensity situation. I mean, your client is there, they're voluntarily giving information, and if they don't follow certain rules that we're going to talk about, then the immunities that we're also going to talk about shortly, so just some foreshadowing, that they're granted in order to feel comfortable or to be protected providing this information, are out the window. So a lot of times when I'm in a session, a debrief or a proffer with a prosecutor or with my client, with some agents, I ask to take breaks if my client needs it, or if my client has a question. They have to honor that. If the client says, I train them and we practice, we do a full run through, usually 4 or 5 hours, hypothetical situations. What signal should my client, say to me, or what should he say to me if he wants to speak in private? The prosecutors and the agents, I've had ones where there's been 30 people in the room. Every single one of them will gladly get out and they will leave the room so you can talk to your client, and they will not hold that against you. Sometimes the agents will ask questions, or the prosecutors will ask questions that I don't feel are fair or that are likely to elicit a response from my client that just he didn't fully understand, or that would lead him to omitting or minimizing. For example, if they say, a prosecutor asks a question, tell me everything you know about the year 2021, or tell me everything you know about X company and your involvement in 2021. Well, should the client be talking about that for 3 hours or 30 seconds? And if they talk about it for 30 seconds, are they omitting? Are they minimizing? So I say, no, you need to ask more specifics. Otherwise, this is not going to work. You can keep the prosecutors in check too, and don't be afraid to do so, or the agents if they're the ones that are asking the questions. Preparation for these is everything. One of the hardest parts about a proffer when you're deciding whether to proffer or not is the client, the start of any proffer session, even if it doesn't happen in the very beginning, it happens 10 minutes in, 20 minutes in, is whenever it is, your client has to accept responsibility in that proffer, or the government will not use him. They'll say they won't use whatever he might have already said, he or she, to that point against him, but they'll say, thank you, we're done here. So I've seen a lot of pitfalls. I had a client come to me where his lawyer didn't prepare him. They went to the proffer in a very big healthcare case, and my client thought that this was his opportunity to defend himself, to explain why the government was wrong. And apparently I wasn't there, but my client said it got very hostile. And from the very, very beginning, he lost trust. The defense lost trust with the prosecutors. It's hard to recover that. Takes a lot of experience and knowing how to recover it. But it can be done. But you want to start off the right way. So a proffer is not a chance for the client to come in and say, I'm innocent. It's not what it's for. It's to accept responsibility, be truthful, and then gain a benefit from doing it. And we'll talk about those benefits. But before we do, probably thinking, well, if he comes in, a client comes in with you and he accepts responsibility, these usually happen in a perfect scenario, they happen before he's been charged. So isn't he just voluntarily confessing? David, I thought you said he should not give up his right to remain silent. That would be really bad. So in a proffer, okay, and this is another huge role of the defense attorney, and one of the most important parts of a case, if you can achieve and can persuade the prosecutor to give your client the opportunity to help themselves by cooperating, they provide something called a castigar letter, or a queen for the day agreement, they call it, or very often a proffer letter. And you'll want to read the case of Castigar. It's a great case. And it basically, what that does is it provides a form of conditional immunity. And there's different kinds of immunity. For the most part, I could talk about proffers for 5 hours, and we have other topics to get to because they're so interesting and they're so important. But really what use immunity is, and what this conditional immunity is if you're being truthful, if you're not omitting, if you're not lying, and if you're not embellishing or exaggerating or minimizing your role, if you're following the requirements that your attorney has explained to you, and the prosecutor always says at the beginning too what is required of them. And we've already gone through, and I'm going to show you an example of the letter, but it lays it all out right there in the letter. If the requirements have been followed, then whatever your client says, okay, during that session cannot be used against your client at any stage. Okay, and that's really important. Really, really important. There's a caveat to that. It's with an asterisk, and there's a few things that can change that. One is if your client lies. Okay, if your client lies, whatever he or she has told the government during that session, it can be used against them. That's why you have to, developing the trust is so important there, because before I go into a proffer session, I have to know everything my client is going to say. Because if I don't know he's lying or she is lying, or omitting, if I have a good prosecutor and they have good relations, then you'd hope that they would say, let's take a break for a second, Mr. Terrace, can you stay and I'll ask your client to step out. I also will regularly during a session ask to take a break, and will ask the prosecutor, are we good so far? Has there been anything that you've found that my client based on the information you already have, which I know you have, that he has violated the terms of this agreement, of this session today so far. For the most part, at least in the Southern District of Florida, they will stop it. They're not malicious, and it can become a big issue later if they know your client is lying and then they elicit more testimony from him, knowing later that they're just going to say, "Oh, he lied, so now I'm going to use it against him." They're better than that for the most part, but again, that's always been my experience. I have had cases where federal prosecutors can really take some liberty, so you have to really be on your toes. And if you don't think that your client can follow those terms, or he isn't ready to, or he's very hesitant, then don't do it. It's not worth it. Other ways that your client's statements could, or he could lose that immunity, that use immunity. And we say use immunity because it's them using statements against his own statements against him, to either build charges against him, new charges, or to make sentencing worse, to use against my client at trial. They can't use any of those. That's use immunity as long as he is following the terms, and we're following the terms of the letter of the proffer agreement. Now, if your client also does decide to testify, because you can proffer and you can still go to trial. You can still say, "We're fighting this. Thank you. We've told you what we know." But your client can't testify if you've proffered. If your client testifies at a trial, and technically the client could testify, but if they've proffered, we've only gotten through a proffer because they have essentially confessed. So you just really wouldn't put a client on the stand at trial, because if they were consistent with their proffer, then obviously they would be saying, I accept responsibility. I did something wrong. So they can't testify. And if they did decide to testify after a proffer, they could be hit with an additional charge of obstruction of justice, which is no good. Something else, one other area is called derivative use immunity. Derivative use immunity, and these are really the three ways that you get immunity, or don't. But derivative use immunity basically means that if your client gives information during the proffer session that's protected, and that information leads them to a source, okay, to another individual, and they speak with that individual, and that individual provides his or her own information about your client, we don't get to go back and say, well, you can't use that because my client told you that too. If the government can establish that they learned it from an independent source, it's complex. I could talk about it more. There's a lot of case law on derivative use immunity. It's highly litigated, but just know that the immunity is conditional, and you really, before agreeing to a proffer, you want to do your research or talk to an experienced attorney about the types of immunity that can be conferred. So I'm going to show you an example of a recent proffer letter. So this is a very good example of a proffer agreement. Each district does them differently. For the most part, they're the same, but there's a few crucial things that you want to have in there. And the defense attorney, we can negotiate what's in the proffer to an extent, but it's very limited. Certain key things we need to have in there. So obviously there's redactions. First and foremost, the witness will answer honestly, truthfully, and completely. Does not in any way agree. This oftentimes says this is not a this paragraph 2 will say this is not a cooperation agreement. Okay, this is not an agreement in any form that says if you proffer to us and you're truthful and you provide valuable information, that we're guaranteeing you any benefit in return other than you have immunity for what you've told us, and we'll see where it goes, basically. And you want to try and get to the next proffer session and keep it going to a point where, if it's in your client's best interest, to then actually cooperate with the government. And then you can get into more what we call cooperation agreements, which is when you really start talking about what kind of better deal can we get, potentially full immunity from a charge if you get in early enough. That's called transactional immunity, you'll see, and it's very, very, very rare. But again, it depends on where your client falls too. If it's a witness or a suspect, maybe you can get it if you've done great proffer. In this case, actually, it was a target. They called a witness, but it does depend, again, why that spectrum is so important. So paragraph 2, they say, we're not making you any promises. Paragraph 3, I love this language. It's not as good as a language as we usually get, but this is what I propose. Unless specified otherwise, no statement made by the witness during this will be offered against the witness in the government's case in criminal chief in any criminal prosecution of the witness or an aggravation of the witness's sentencing for the matters currently under investigation in accordance with sentencing guideline 1B1.8, except in a prosecution for false statements, obstruction of justice, or if they've lied during the proffer or otherwise omitted or minimized or violated the terms of the letter. So, practice tip: any proffer letter that you have to make sure that it mentions sentencing guideline section 1B1.8. This is the guideline that talks about what the government, prior to a sentencing, will provide to the probation office. I don't want to jump ahead too much, but when we get to sentencing, probation office and what they provide to the judge prior to a sentencing, based on something called the pre-sentence report or pre-sentence interview. They have it in state court as well. It just happens in every federal case, unless you have had a case dismissed by a motion or not guilty or other means. There will at some point be a pre-sentence requirement investigation for felony cases. And this guideline here, this letter, it's not in every letter, but it does basically say that whatever was said during this proffer session cannot be given to, or will not be disclosed to probation, because probation is an arm of the judge. And the judge, whatever probation has of the court, whatever probation has, the judge can have too. There's no immunity or no privacy there. So why is that important? That line basically means your sentence can't get worse if probation learns about this and discloses this information, where it could be very damning against yourself, but you're doing it to help yourself, so that the judge doesn't know at sentencing. So 1B1.8 is really important to have in here. Paragraph 4 is about derivative immunity. We talked about obtaining leads. If your client testifies, we talked about at trial or otherwise, then what has been said in the proffer can be used for impeachment. They can be cross-examined with it if their statements are not consistent with the proffer, which they never would be. Otherwise, we're not proffering, which we don't always do. If we want our client to be able to preserve the right to testify, it's important to our defense, and this appears to be a case that looks more like a trial case, then proffer is not common, especially if we believe it's crucial to our defense to have the client testify. So the witnesses waive any right. This line here, 6, is talking about these codes. The Castigar case is whittled down to these codes. You can read the case, and they're not going to be recorded. no additional promises, agreements, or conditions entered into, and none will be entered into unless signing of the party. And the assistant United States attorney signs it, the agent who is present signs it, the attorney being me, and the client signs that. So that's the Castigar letter. All right, moving on now to charging. Obviously, the next big stage. Everything we've talked about so far from the very beginning is all really related to charging, and a lot of these processes happen at the same time. Advocating for a client on charges starts from the very first time you speak to law enforcement. And most negotiations, I'm sorry, we have a question, so one moment. The question is, would you encourage a client to disclose all criminal activity when proffering in order to cast a wide net of immunity, or is the proffer very prescribed? So, really great question. You always want to advise your client to just answer the question that's asked. You get to a certain point, if they've answered the questions just as asked without trying to give more or give what they think the prosecutor wants to hear. And if they don't know how to answer the question as asked, then we ask to rephrase. But you don't want the client, certainly for the first session, disclosing criminal activity that wasn't asked about. But the client, they might say, I had a case that was illegal wildlife smuggling from Australia, a serious wildlife case, for as serious as they can be. They're very interesting. And my client was asked towards the end of the first proffer session, and we prepared for it, have you ever smuggled wildlife before in any fashion? That's, I think, going to your point, it's a really hard judgment call, and your fallback is always they already know the answer to the question, okay? Because if you don't cast this wide net, or if you don't answer the question because you're like, well, this is not even what this case is about, then, and they know that you've done it before, well, then your client is screwed and you've done a terrible job as your attorney. So basically, yes, any criminal activity that is asked about should definitely be provided and answered truthfully. As the attorney, we want the proffer sessions to be prescribed as much as possible. One of our goals, a practice a tip, is you want to have a conversation. I always try and have at least a video call, if not a sit down, before the proffer session to find out what exactly they're going to be asking my client about. Some prosecutors like it depending on the case or just the prosecutor's own way of investigating. Others do not. Others want to catch your client off guard so he doesn't have time, he or she have time to prepare his answers. But as the attorney, you want it to be as clearly defined as possible. Otherwise, you don't know what your client might say if you haven't been able to prepare for it. So that's why the preparation is so important as well. So yes, to answer your question, you want to answer everything they ask so you have that use immunity for whatever they ask. And I've had clients who have admitted and confessed truthfully to crimes that were not under investigation, and they did receive immunity for those because they were the only source of discovering it. So it's very important, but your client has to know that. It's not easy to have a client go in there and if he's accused of smuggling tigers to then just offer up, have you ever smuggled anything else? Well, why would I tell them that? I'm just going to get charged again. I always say, if you're not prepared to answer that, then we shouldn't do this because they might already have the answer. So hopefully that answers your question. So some of the fundamentals of charging, again, this process starts for it starts in the very beginning. Most negotiating, successful negotiating happens before the charges are brought. Your ability to affect a outcome of a case that you're trying to resolve in federal court is limited. It's very limited, and that's why it's very difficult practice, but very rewarding. It's not like state court. One of the main things you can negotiate, often the only thing you can negotiate, is what charge are we going to proceed under, and how do we get there? By proffering, by giving us leverage and cooperating, and then that's when the negotiation starts. Sometimes before, sometimes after, but it very, very, very often starts at the very, very beginning, because that's the benefit that you're getting by cooperating. If you are, is a reduction in charges or no charges at all. And prosecutors very often say, and it really is the truth, the best offer you're going to get is the one that we're able to negotiate before we have to go to a grand jury. And that's for several reasons, because if you negotiate the charges prior, and you can negotiate the charges prior to a grand jury, in the very beginning, you can say, we negotiate, my client will, in order to not go through the process, not make you go through a grand jury, save taxpayer dollars, pandemic, things like that. We will agree early on to agree to a charge, not necessarily what the plea will be, but we will sign a draft of a plea and commit to a one count of a wire fraud. Whereas if you went to a grand jury, they could come back with 25 counts of wire fraud. Or if there's 1,000 emails that are fraudulent sent to somebody if I'm in Florida, sent to Georgia, technically they could come with 1,000, but they don't do that. But very common in child pornography as well, is to say, we'll agree to not make you go through a grand jury if you don't charge every image or every video. So definitely starts very early. And then the one caveat to that is you can also get better deals if you find some sort of major evidentiary hole and you have a great motion to suppress, or their trial starts falling apart. That's common in state court, where we can beat the prosecutors up with motions and smoke them in trial. Federal process is different. It can still happen, but it's just simply not as likely because of the nature of the investigation that they do and the resources that the federal government has compared to whoever your local law enforcement is or state law enforcement. So in the slides, I talk here, this is again the DOJ manual, which is great, that the reasons, the fundamentals of why a prosecutor should bring a charge. It's good to know, especially number 3 is, this says they should bring a charge sufficient to obtain, if the evidence is sufficient to obtain a conviction, unless prosecution would serve no substantial federal interest. That really means that it's a state matter. The person is subject to effective prosecution in another jurisdiction, does happen, and there exists an adequate non-criminal alternative to prosecution. They don't really go on that, especially since the pandemic, when there was no grand juries and the Department of Justice gets paid based on grand juries and convictions. So they are really taking everything they can now. Non-criminal alternatives are much more difficult than they were before the pandemic, for how much money was lost by the federal government during the pandemic. DOJ Justice Manual is great because it's in their own terms and can be used against you. It lays out the standards for them to follow. For example, DOJ 9-2730, and there's a link, selecting charging the most serious offenses. It's very, very detailed. I highly recommend that you rely on this DOJ manual. It really, really helps you understanding understand where the government is coming from. And it's not like you're in state court and when we're there, we're seeing the prosecutor every single day in the morning in the courtroom. We know their attitude and we know maybe the training that they receive at their office. We're different dealing with the federal government, so rely on their own manuals. So different kinds of charges that can be brought in the federal system. And just a note as well, you'll often be told by a prosecutor that they have to check with the supervisor. Maybe that's a ploy in state court that you've heard. It certainly happens in South Florida, where really that's just a way of them passing the buck on why it's a bad deal. But in the federal system, that's the truth. And you can read more about that. I won't take too much more time on that. So grand jury indictment, that is the most common way. Anybody who has been accused of a federal crime or arrested for a federal crime is constitutionally entitled to be charged. A felony crime in the federal system is constitutionally entitled to be charged via indictment. They can waive that constitutional right, which we'll talk about. Witnesses, grand juries, we're not going to go too much into it, but this is what a grand jury indictment looks like. Has the charges on top, the names of the defendants, and then it'll have the counts, and then the acts that constitute the counts. And sometimes they're short. I have an example. If I have time, I can show you. Recently that I have is a 71-page indictment. We have no role in the grand jury. So grand jury is dangerous. Grand juries involve 16 to 23 members, and witnesses are compelled to testify, and you are not allowed to have an attorney present if you're compelled to testify. And 12 of those 16 members have to concur. Everything is sealed with a grand jury. It's the most sealed thing. There's no cracking into a grand jury. We have no role in it, and a grand jury really is a rubber stamp. So you'll see here, you may have heard the expression that prosecutors can indict a ham sandwich, or a grand jury is just a rubber stamp. It's terrifyingly accurate. It really is. A couple things. Grand jury, they're secret, closed to the public. We have no opportunity to present evidence, challenge the prosecution's evidence. This is also a standard of probable cause for the grand jury, which if you've practiced in state court, we're familiar with probable cause. It's the same thing. It's one of the lowest standards in criminal law, maybe a little higher than reasonable suspicion. It's defined as requiring only sufficient evidence to lead a reasonable person to believe that a crime has been committed and that the defendant is guilty. Very different than beyond a reasonable doubt. So when the prosecutor goes to a grand jury, they pick and choose what to show them. If we have provided during a proffer session that ultimately didn't result in us working out an arrangement to avoid a grand jury, but evidence that's weak for them, they have no obligation whatsoever to show that to the grand jury. They very much cherry pick the worst of the worst. Okay, just going back to a concept that's important for that before, when we were talking about proffers, I failed to mention something that is known as a reverse proffer. A reverse proffer is absolute huge goal of an investigation stage of the case. That's when you and your client go in and the government lays their cards out on the table to you, and your client doesn't have to say anything yet. And if you can negotiate for one of those, that's great. The prosecutor describes the evidence, and in some cases, pretty much what that is they'll be showing you the worst bits of evidence that they'd be showing to a grand jury. Reverse proffers are often take place when their prosecution wants to just convince someone to plead guilty, more often when they want to convince them to cooperate. Sometimes those go hand in hand. I always do whatever I can. You can reach out to me. You'll have our contact information. I have a lot of tips for how to persuade a prosecutor to give you a reverse proffer. But reverse proffers are super important. The reason I bring that up is because the most we'll know about a grand jury is if we can get a reverse proffer where the government shows us what they have, because that's going to be what they're going to show to the grand jury. So that helps us really determine and manage expectations and set our goals as to whether or not we're going to be waiving indictment. I can see in the reverse proffer, say to my client, this stuff does not look good and we've spoken a lot and this seems pretty overwhelming. We should try and cooperate. So all these things kind of work hand in hand. So indictment, sometimes we talked about this, sometimes we decide to waive indictment. That can be usually if our client is cooperating, then there's no need for them to go to a grand jury. Sometimes, depending on the case, the prosecutor you can agree to an information, which we'll talk about as well, is one of the three types of charges or initiating a case, so to speak. You can waive your right to indictment. Sometimes that's a good idea because you can say to the prosecutor, listen, we can agree that my client will proffer, we're going to be going forward. We're not ready to accept a plea, but if you allow him to proffer and provide information that you can at least evaluate and don't require the client to plea first, because sometimes they will make your client enter into a tentative plea before they allow your client to proffer or do a reverse proffer. You can negotiate and say, all right, we'll agree to an information on one count of wire fraud or one count of child pornography, as opposed to going to a grand jury, and then grand jury could come back with 50 counts. And that's a problem. But usually if there's no proffer, no breakdown, no good line of communication with the prosecutor, then it's hard to convince them to do that. But it is something that can be accomplished. And again, anybody who's watching is welcome to reach out to me, and I can talk about some of the tips on how I do that. There are indictments can't be amended once they're filed, but there can be what's called superseding indictments, second, third, fourth indictments, often adding co-defendants or new charges, and then it replaces the original one. So that's known as a superseding indictment. But there are motions that can be filed to challenge the indictments. So we also have information is the other main part. Indictment is the primary method for certain crimes and certain conditions. We can maybe negotiate a criminal information. Criminal complaint also formally begins a case, but a complaint is really the equivalent of a probable cause affidavit. It's what was necessary in order to make the arrest, but not what was necessary. It's not a charge in and of itself, but it does give probable cause to arrest pending a charging decision. Sometimes, often, I wouldn't say as often, but a lot of times your client will come to you and they've already been indicted. And then at that point, a lot of this becomes superfluous. Information is a formal charging document, describes the criminal charges against a person and the factual basis, does not require a grand jury. Information is presented to a judicial officer, the prosecutor writes it up, and just the magistrate makes a determination if there is probable cause and then can sign the information. Complaint is like a very prolonged probable cause affidavit. it allows for an arrest warrant or an arrest to be made if there's exigent circumstances. They all serve the same function in that they all start a criminal case and inform the client of the charges against them. And they also ensure that a prosecutor has sufficient evidence to establish probable cause that a crime has been committed. So a little bit more about informations and complaint. Again, happens most frequently when the defendant and the prosecutor have reached an agreement as to a plea, to a particular tentative agreement, or agreed to waive indictment, and where the final plea is to an offense different than originally charged. Informations are also used. There's a lot of litigation going on right now about whether or not this is ethical or is appropriate or legal. But an information could be used to avoid violating the statute of limitations. A lot of debate going on right now, at least I know in the Southern District of Florida, because of the pandemic, there was no grand juries for almost 2 years, and prosecutors were getting really close to their 3 or 5 year statute of limitations. So they were just going ahead and filing informations to at least toll the charges. As defense attorneys, we're fighting this hard because we're saying our client had a right to an indictment. So what a couple of judges in the Southern District of Florida have ruled is that it's okay as long as the assistant United States attorney or the United States attorney dismisses the information and files an indictment. Then our client's rights to an indictment were not violated because they got it anyways. And there is the law, I don't believe, is really clear on whether that's an acceptable form of practice. Complaints are used when arrests need to happen quickly, more like how a state court probable cause affidavit. They don't have time to go to a grand jury, so they do a criminal complaint that's drafted by the agent, whereas the information is drafted by the prosecutor. The prosecutor signs off, they still review it, and if the complaint is sufficient, then they'll issue an arrest warrant. Once an arrest is made on a criminal complaint, federal law requires that the defendant must be charged by an indictment or by criminal information if there's an agreement. Misdemeanor cases, you do not. Federal misdemeanors are rare, but you don't have a right to be charged by indictment, or the defendant can waive indictment, and that is within 30 days. So this here is a criminal complaint, basically the federal version of a arrest report or a probable cause affidavit that you might be familiar with. And this is a recent case of mine that's public record. Usually starts with the affiant's background and why they have an expertise, which is required for them to be able to show expertise in the area that they're seeking a complaint on. Then it'll go into probable cause, just like it would in a state case, describe the nature of their investigation to date, and ask for a complaint to be signed so that an arrest can be made to at least maybe if they have fear of a flight risk, or if they've already established enough probable cause to arrest the individual and they don't need to continue their investigation any further at that point. I'm going to show you now a copy of an indictment. So this is an indictment. This is a case out of the Eastern District of Michigan, out of Detroit. You can see that there's several co-defendants here that are listed. Zoom in. Has the violations. These are the co-defendants, the grand jury charges, general allegations, free band gang. And I'm just going to kind of scroll through. You can see how extensive these are going to be. in some certain cases, it's a lot of work to get a grand jury indictment. Conspiracy to commit wire fraud. They'll talk about the object of the conspiracy, the manner and means of the conspiracy, and just overt acts. Any conspiracy, and the law on conspiracy requires at least one of the co-defendants have taken some step towards the goal of the conspiracy, achieving the criminal activity. Everyone else just has to know about it. Conspiracy is a whole other topic that you have to be familiar with in federal criminal defense, because it's very common and it's very hard to deal with. So yeah, this is just going to scroll through quickly. You can see how encompassing an indictment can be, and how much investigation can be done in an indictment. And it's just 71 pages more of this. So it's a process, and you have to review it very thoroughly. So general practice tips with charging. Negotiating charges with prosecutor prior to the decision. We talked about that. Super important. Just makes you look amazing, and it's all about the client. It's not about how we look, but by doing something amazing for our client, we are also just looking great and building that trust. Talk to the prosecutor. Have that open line of communication about arranging for a voluntary surrender if they're going to be charged. Find out when the grand jury is, find out when they intend to file the information. Most prosecutors are maybe, at least in the district I've practiced in, and prosecutors seem to be very receptive to allowing your client, with counsel present. I will go with my client to the courthouse on the day of his first appearance after the charge, and present him voluntarily, so he doesn't have to be put in handcuffs and go through that traumatizing experience. Because, of course, one of our goals is just not to let our clients get traumatized by the system any more than they already have. So we're going to talk briefly about initial appearance, arraignment, and bond in the federal system. Most of it is, you can just read the rules and it's relatively clear, but it is very different than in state court. You have an initial appearance, which is covered by Rule 5. Hopefully that initial appearance is one that you can pre-schedule, agree on a time with the prosecutor, and agree to walk in with your client and have the bond agree to as well. And they can be out. They don't have to spend a night in jail if you can accomplish that. That, whether they're willing to do that or not, is one of the primary incentives to one of the incentives. I wouldn't say primary, but one of the incentives to cooperate with the government in whatever way makes sense for your client, is that they'll very often say, okay, if you cooperate, we'll agree to not only the voluntary surrender, no arrest, no complaint, but also agree to a reasonable bond as well. So what happens at the initial hearing, it's within 48 hours as opposed to 24. They don't do holidays or weekends either in federal court, which they do in state court, and that can become annoying. It's handled by a magistrate judge. He will advise the defendant of the charges against him or her, the maximum sentence. If there has been at least a complaint, if they're already there, they've been arrested, there should already be a complaint. If they've received a copy of it and have reviewed it. If your client is arrested and you get called while they're in jail, you usually don't get the complaint until that morning. Was a lot easier before the pandemic to then go to the courthouse and have an opportunity to sit down and review it with the client. But if they are just handed the complaint, obviously every one of our clients' intelligence levels is different, their reading capabilities, their literacy. So it's been an issue during the pandemic, whether they've had a chance to review it. If they haven't, then the judge will read the complaint. And that's like in state court when usually you say, well, waive reading. If they haven't reviewed it, then the judge will read the complaint. He will advise, the magistrate will advise your client or the defendant of his invocation rights, his rights to remain silent, his rights to counsel, and ask whether he already has private counsel, intends to hire private counsel, or needs counsel to be appointed to him because he's indigent, and then he'll do an indigency application, just like if you've practiced in state court or if you've ever been a public defender, which I was. Of course, you're entitled to representation under Gideon. If there's already a charging document, such as an indictment or an information, by the time we go in, and that's usually if we voluntarily surrender, that means there never was a complaint because there never was an arrest. So there already is a charging document that we've agreed to. We can either ask, or the magistrate can ask, to handle the arraignment at that time. We can plead not guilty always, even if you have an agreement with the prosecutor. I want to be very clear beforehand. You always still plead not guilty because it's not that agreement has not yet been entered into the record. So client could potentially change their mind if with consequences. If an indictment or information has already been filed, it can be entitled to a preliminary hearing under Rule 5.1. It's like an adversarial preliminary hearing in state court. If a client has been arrested on a complaint, then it's, I believe, within 14 to 21 days. I'm blanking now on Rule 5.1. But certainly within 21 days, you have to have a mini trial on whether there's probable cause for them to remain in custody. But preliminary hearings are not that common in private practice. Good practice note, something that's very different. If you're entering your appearance for a client, either at their first appearance or at arraignment, the judge will ask you whether you have filed a temporary or permanent appearance. Not really common in state court. Temporary means you're only there for the purposes of your only representation duties are the detention, bond, in terms of release, and that you're not the actual defense attorney who's going to be receiving the discovery, who's going to be arguing motions, filing motions, going to trial. Or if you enter into a permanent appearance, that means that you're all the way through, but you should also notate on the filing and in court whether that includes any sort of appeal or post-conviction, if there is one, because the judge will ask you it. I always like saying it first. It gives you a lot of credibility, especially when you're new to federal court, because the judge will ask. So you can say, Judge, I've entered for permanent appearance, and the permanent appearance is to trial only. Doesn't mean you're going to trial. It just means that you're not doing any appellate work on the case, or you haven't been retained to yet. So the bail process is somewhat similar, but also somewhat different, and it can be often more favorable than in state court. The government can move for detention at the initial appearance. You should definitely, or you have to, be very familiar with 18 U.S.C. 3141 and certain kinds of cases, depending on the nature of the charge, which is laid out here. That's under 3142F, under 18 U.S.C. The government can automatically ask to detain your client for 3 days to prepare for a bail hearing. So it doesn't always happen like in state court at the initial appearance. It's more like a bond motion in state court, I guess, but it happens quicker probably than a bond motion, because depending on what district you're in. Case that involves violence, maximum sentence of life, minimum mandatory sentence of 10 years by the Controlled Substances Act, which is a lot of drug trafficking, or if any felony if the person has been convicted of 2 or more. Those are cases where they can ask for your client to be held an additional 3 days without a bond to prepare for a motion. And the motion is essentially those they get 3 days for. They can also ask for a motion or a bond hearing to be set, even if your client is released. They can ask, still file the motion to have pretrial detention. Not as common in all state courts, in all counties, like where I am in Broward County in South Florida. It's common in Palm Beach County. It's never really a thing. But in federal, they can do that if there is a serious flight risk, or if your client is a danger to the community, similar to state court. The defense can ask for up to 5 days to prepare for that bail hearing or that detention hearing, if we so choose. So types of bond are a little bit different in federal court, and you want to be really up on them. You have personal surety bond, which is not a thing in state court. 10% bond is very similar. Well, it's similar to state court process of using a bail bondsman, but with no bondsman, 10% paid directly to the clerk. Corporate surety bond is a bail bondsman is required, and in federal they take 15%, and the entire amount of the bond has to be collateralized with assets, usually a home. Personal surety bond is where in the best case scenario, if you can negotiate for it, you can negotiate that client just has to sign a paper saying that he'll be responsible for $100,000 bond if he violates, but he doesn't actually have to put up any money. Sometimes the court will, or often the court will require co-signers. Sometimes family members are acceptable, or other people who will co-sign. And if there's a co-signer, the court will usually need to determine that that co-signer has property that a lien can be placed on if there is a violation of the bond terms. But personal surety is the best option. There can also be different kinds of conditions that are put, like in state court. There can be mandatory substance abuse testing, drug evaluation, house arrest, home detention, and different forms of that with an ankle monitor, sometimes with a GPS monitor, sometimes with more of just a curfew geofence monitor. You could be released on a personal recognizance, but it's really never without conditions. So sometimes personal surety is just better if your client, intends to stay. And so just go ahead, read 3142, 18 USC 3142, clear as day. But you want to know it really, really well. Practice tip: try and get a personal surety bond. Most important difference with federal is because you can negotiate bond, you might already be in a 3-month-long process of negotiating terms with the prosecutor, charges and bonds. And if you're going to negotiate a bond with them and be willing to a charge or be willing to cooperate, and cooperation is going well, fight really hard. Always fight really hard, but fight really hard to make them give you a easy bond, because of course that's one of the most important considerations of any of our clients is their freedom and their ability to get out. Have a co-signer ready to go beforehand. Don't wait until the last day. Have a bondsman ready who's prepared to accept the bond, and make sure it's a bondsman that works in federal court and has connections with the U.S. Marshals. Be prepared in advance. If you need a bondsman, call me. Be prepared in advance for possible nebia. Nebia is also a state court concept. It's very common in federal cases, especially ones involving financial crime and drug crimes, narcotics crimes, basically saying that the court has to be confident that whatever collateral or whatever money is being used, put up as collateral, or whatever money is paid as a bond, has not been unlawfully obtained. Otherwise, there's going to be a nebia hold. If you do get to a bail hearing, call witnesses, members of the community, family, friends, put on a full bond hearing to show why they're not a danger to the community. Also, it's really important to know the standards of proof because these are pretty nuanced in federal. In a pretrial detention hearing, which is brought by the government, it's actually the government's burden to establish by clear and convincing evidence that no conditions of release will reasonably assure the safety of the community. That's usually reserved for the most violent crimes or sexual crimes, but not even so much sexual. Well, that's violent as well, but murders and robbery, things along those lines. Standard is different when the issue is whether any condition of release will reasonably assure the defendant's attendance at trial. That's the risk of flight aspect, not the danger of the community. Then the standard is not clear and convincing evidence. It's preponderance of the evidence, and they get to choose which one. So they could just go on flight risk. That happens if your client often is a foreign national, but in response, we will stipulate to waive extradition and surrender a passport, and that helps. But they can go on either one. But the standard is the burden of proof is on the government there. So moving on to discovery and pretrial motions. Not going to spend too much time on discovery. I'm kind of going to go through this pretty quickly. The discovery rules are things that you can read about and can look up online. There's not so much nuances to it. We'll talk mostly about the nuances. Federal Rule of Criminal Procedure 16, 26.2, and 18 USC 3500, which is the Jenks Acts. That's the really nuanced one. Brady versus Maryland, same as state court, requiring any and all exculpatory, inculpatory, or inculpatory information to be turned over. Brady and Giglio requiring those. And we'll talk about Federal Rule of Evidence 404B, which is a pain in the butt. Practice tip, try to negotiate with prosecutors to get discovery disclosures as early on as possible. Set timetables out when you're going to be getting those disclosures. It also helps. You can ask the prosecutor if they can send a letter attached to the disclosure explaining the discovery. It saves some time. And know these rules above really well, and definitely know your local rules as it relates to discovery. So practice tip, demand discovery at initial appearance arraignment if your district allows it. Most of them do. Sometimes you don't even have to ask for it at the initial appearance. Or if charges have been filed, more likely at arraignment, the government will issue a standing discovery order. And this is an example of what a standing discovery order looks like here that you can review. How discovery is produced varies by jurisdiction as well as the case. Sometimes it's hard documents we get in the mail. Sometimes it's hard. We have to provide a hard drive depending on the district, how much discovery it is. In a healthcare fraud case I have right now, it's over 7 million documents, so it's a big hard drive. DVDs, cases involving sensitive information or vulnerable witnesses, you have to sometimes do what's called an evidence view, similar to state court. That's very common in child pornography cases, of course, where the evidence can't be disclosed to you. It has to be viewed at the FBI's office. And so you're going to want to have to go there if you take on those cases. We have many of them and they're tough, but that you're going to have to go see in person. Be prepared to have a document review system in place, at least a Dropbox if you're doing financial crime, which can involve hundreds of thousands or millions of documents. See if the prosecutor will create a hot docs, they call it, which is kind of a way of getting an early exhibit list. It's usually going to be, if in a big case, around 500 to 2,000 of the most pertinent documents, so you can at least get started with your client on those. But you're definitely going to want to have a system in place for sharing those documents and managing them. Quick note regarding discovery and federal, huge difference. You're not getting depositions. Rarest circumstances. but do not expect to ever get a deposition on a federal case. And that's part of the reason why so many cases resolve. Just a bit about Brady Giglio requirements, disclosure of exculpatory and impeachment evidence. Rule 16, familiarize yourself very well with Federal Rule 16. These are all these things here, what the government must disclose, statements by employees, relevant oral statements. Just for time's sake, I'll just have you go through that yourself, familiarize yourself with it. There's nothing too nuanced about it. But it is important to note that it does not authorize the disclosure of reports, memoranda, and other internal government documents made by an attorney for the government or other government agent in connection with investigating or prosecuting the case, so basically work product. So Jenks Act. Jenks Act is a very nuanced one. So under the Jenks Act, the government must produce the prior statement of a government witness only after the witness testifies on direct examination. For a while, that was only at trial. Now it applies to suppression hearings, habeas corpus, or other forms of post-conviction or interlocutory appeals type of situation. Rule 26.2 basically took the Jenks Act and said it applies to things beyond trial, sentencing hearings as well, preliminary detention hearings. This is really difficult. In federal trials, in state court, you get everything. You get any report that the law enforcement officer issued, things along those lines. You basically get their work product, supplemental reports. In a federal case, you might not, and very often won't get the report that the witness for the government is testifying about or relying on until after they're direct. You can imagine it makes cross-examination quite tedious. You have to be prepared for it. The federal trial is not easy, and Jenks is one of the main reasons for that, is because you're not getting some of your most necessary discovery to prepare for cross-examination, to prepare to impeach them with documents, the government's witnesses, until after they've already testified. Most federal trials, you're spending the night after the trial going through the Jenks material that was turned over that day. File motions to compel and just try and get as much as possible from the prosecutor. So 404B is basically the equivalent of other bad acts or Williams rule in state court. Very difficult. Do your best to find out if it is going to be coming in, because it can come in really at any time, and in reasonable advance of trial can be a week. And this is them bringing in other bad acts that they can use against your client. You have to be prepared to file motions to eliminate 404B evidence. It's one of the strongest tools that the government has. And ask them early on if they expect 404B, because that definitely is a big factor in whether you're going to try and resolve via plea or go to trial. Pretrial motions, very similar to state court. These can include motions to dismiss charges, suppress evidence, bill of particulars, motions to strike, motions in limine. Most important nuance here that I would advise for our purposes is Rule 12 lays out exactly, Federal Rule 12 lays out what the motions are, but consult your local rules. Don't file a motion, Adam said earlier, and go in and have a judge say, this is 11 pages. This type of motion in my district requires 10. Not a great look, especially for an early practitioner. Consult your local rules. If it's not clear in the local rules, consult somebody in your district, a colleague, or I'll help if it's in my district. Plea bargaining. Definitely the most fluid stage of a federal criminal defense process because, as you can see, plea bargaining is happening throughout. It can happen from the first call with the prosecutor up to the day before, well, not the day before trial. Judges usually set, in most districts, in my district and other districts I'm in, they set a time for when you can enter, the last date you can enter into a plea, which is also not like state court. But it's a very fluid process. Very different than at the state level. Plea document in federal court is a very long document. In state court, plea hearing usually takes about maybe tops 15 minutes if you have a slow judge, sometimes 1 minute. Federal plea colloquy is a very, very lengthy process. The plea agreement itself is very lengthy and requires a lot of terms. You need to be familiar with it. And I would say that by far the most fundamental difference and the most fundamental thing to know about a federal plea is in state court, a negotiated resolution with a prosecutor is always going to be to a certain amount of sentence, okay? Every single case in federal court, whether you have a plea bargain or not, unless the client's found not guilty or the case is dismissed through a motion or otherwise, goes to a sentencing hearing. Anything in the plea agreement that you have is only recommendations. Only recommendations. The judge can reject all of them. No matter what you put in the plea, every case is going to a sentencing hearing. And it's a very serious hearing. It's a trial on what the person's sentence, their punishment should be, and that is strictly up to the judge. Prosecutor could say, Judge, this is the perfect recommendation. The defense agrees. Judge could rip it up and say, well, here's what I'm going to do, and we're going to talk about why. So the document itself is certainly negotiated. A lot of it is boilerplate. But first, most important thing, what can you really negotiate if the judge is determining sentence anyways? Negotiate what charge is being pled to. And we've talked about that. That can start from the very beginning. So instead of 25 counts of wire fraud, we'll plead to 1 count of wire fraud. We'll talk about sentencing, but that of course lowers somebody's exposure. Any plea in a federal court is going to have a factual basis. The federal plea agreement, it does have a substantial impact on sentencing, lays out the unlawful conduct that was committed. Sometimes it's in the plea in certain districts, sometimes it's a second document, and it will likely include basically making out all the elements of a crime and what the prosecutor would have proven beyond a reasonable doubt each element had the case gone to trial. And the factual basis can be negotiated between the defense and the state. Contains stipulations about the loss amount, which is huge in white-collar cases because money controls everything in white-collar cases when it comes to sentencing exposure. Critical factor, we'll talk about the guidelines. If you can't agree to a specific amount or specific recommendations, you can stipulate to a range of potential loss or potential enhancements, and that will still ultimately be up to the judge, but it will help give your client some expectation of what they're going into. Plea bargaining, plea agreements involve a waiver of appeal, okay, and they're limited waivers of appeal. There's certain ways that you can never waive an appeal, one of them being ineffective assistance of counsel, also some things related to sentencing that we'll talk about. But the plea, there's a lot of anxiety in federal plea bargaining and sentencing for the client because they're pleading to something and you can do your best determination of what their sentencing guideline range is going to look like, but ultimately it's going to be up to the judge. So the plea agreement can say which recommendations the parties can put in the plea agreement were recommending that certain sentencing factors apply and certain don't. And guidelines and guideline factors we'll talk about, but it's only one portion. There's things that you can stipulate to. There are ways to limit down, even though you can't say agree to a sentence, you can limit to an expected guideline range. And if you know your judge, which you must know your judge that you're going in front of, especially for sentencing, you need to know, crucial, you need to know, is this a judge that regularly sticks to the guidelines? Or is this a judge that is common to vary lower, to vary above? These things are very important. It's a good idea to try and have the sentencing enhancements locked in the plea agreement itself. So there is less unknown, and that can be negotiated as part of the plea bargaining. Again, the judge is not bound by these, but most judges, at least in the Southern District of Florida, I've rarely, if ever, will have a judge not follow the recommendations as far as sentencing enhancements and sentencing aggravators under the sentencing guidelines, which you have to be an expert in as well. So before we talk about go into sentencing, I want to talk, I don't have a slide, but I want to talk briefly about trial. Just some of the nuances. If you tried cases in state court, if you're great at trial, you're great at trial. Of course, whether it's state or federal, you need to know and be familiar and be an expert and be ready to zealously advocate on behalf of your clients. But some of the big differences that I'll just point out are 12 jurors always on a felony in federal, where it's you only get 12 in state court for capital. Biggest problem for defense attorneys, why trial, one of the many reasons why trial is very difficult in federal court, is a majority of judges do not allow the defense or the prosecution to do any voir dire ourselves. The judge either does 90% of it, or some judges you have to know. Sometimes it's in the judge's divisional instructions, but you want to find out, does your judge allow the parties to voir dire, to question the panel? What they do allow in federal is you can submit proposed questions that you would like the judge to ask the panel, supposed voir dire questions, and the judge can incorporate them into his or her voir dire, but it's completely within the judge's discretion. And if they don't ask your question, or if they ask a question that the prosecutor asks for that you don't think they should have, then all you can do is object and preserve the record for appeal. But they do have discretion to choose their questioning. Every district is definitely different about that. Every judge within districts is different about that. So you really want to know in advance whether or not your judge allows the attorneys to voir dire the panel or only submit proposed questions, and also how much time they'll give you, because we're used to state court, on a serious felony, we're getting, depends on how serious, but we're getting anywhere from an hour, and if we're doing a homicide case, sometimes we're getting days. Or a serious, state white collar case. In federal court, no matter what the charge, in Southern District of Florida, majority of judges, if they are letting you ask, you're getting 10 to 15 minutes tops. And the judges are really strict, and they will really jump at you. If you present, you have to present them the questions that you're going to be asking. And if you don't stick to that, they will make you pay in front of the jury, which of course is a terrible look for the client. So voir dire, getting the right panel, you're really, really relying on the judge to do that, which voir dire, in my opinion, in state trial is the most powerful tool that we have, is our ability to question the jurors as much as we please and on the topics that we're legally allowed to. Another nuance of federal trial is that in state court, usually only the prosecutor has to submit jury instructions to the judge. We review them and we say if we have any objections. In federal, both sides, the defense also has to do pattern jury instructions and any proposed jury instructions, and you have to file a motion about why you feel that proposed jury instruction is appropriate if it's not a pattern instruction. The state and the defense have to do that. And the judge does have to let the parties know if he intends, he will let the parties know, him or her, that he intends to rule on which instructions will be read. And all you can do if he says, I'm not granting your instruction, is object. And you have to have really specific grounds. You have to be really prepared. Just objection by itself is not going to preserve your appellate record. So we'll go into sentencing. I did actually first, just before we go to the topic, before we skip plea bargaining, I want to give you an example. I'm going to share my screen here. So these are some examples that I pulled of, and I felt that this was really important for the purposes of this CLE, being it's a practitioner's guide, is there's only so much you can. Most of a plea is boilerplate, but there are the main, other than the charge itself, the main thing that we can negotiate is the enhancements, and we'll talk about sentencing enhancements under the guidelines when we get to sentencing. This was an interesting one. You can see we agreed to plead guilty to counts 1 through 3 of the information, which charge receipt of kickbacks in connection. This was a healthcare fraud case in violation. I was able to negotiate, so there are things we can do. I was able to negotiate this language that in consideration of the undertakings contained herein, this office being the U.S. Attorney's Office, will not pursue any additional charges under money laundering statutes 1956 and 57 and wire and mail fraud statutes here, which they could have, but because we pled and because we cooperated, that was one of the concessions that we were able to gain, and one of the negotiations that I was able to successfully pull off, which will save my client, of course, a ton of exposure. Not pursue any additional charges under these statutes related to the defendant's involvement in criminal activity in the Southern District of Florida that was known to this office as of March 2020, when the parties originally entered into a plea agreement. In that case, the plea agreement had changed a few times. But this was so great because these statutes all carry between 20 years to 30 years. And the statute, or the counts that we were able to negotiate, they carry with it a cap of 10 years. So you always want to go for the charge that has the least cap. This was another one, just an example of where we can really negotiate the charges or the enhancements as part of a plea. This is a joint recommendation that related to the guidelines shall be calculated pursuant to 2 offense level first. Base offensive level should be an 8. The loss amount should be between these here, 15,000 to 40,000. All of these directly correlate to what the guideline range of potential sentencing exposure could be. And we agreed to a 2-level increase. For certain reasons, we were not able to get acceptance of responsibility. And we also negotiated the criminal history points. We negotiated the points here regarding being on supervised release. So if you can do this, and if it's favorable to your client, if the prosecutor is willing to, it's great, because you can give your client a really strong estimate of what the guideline range is going to be, and then where additional variations downward, hopefully, can go from there. But at least having a strong idea of the guideline range is crucial. This was what the best example that I had. The language, I would strongly advise you try and include this in your plea, where it says this office and defendant agree to jointly recommend that the only sentencing guideline enhancements applicable to defendant's charge conduct are as follows, as opposed to this language in this other plea. These are different pleas. The office and the defendant, they will jointly recommend that the court make the following findings. This is just stronger language, and this is more favorable language. So copy this language and try and get it as part of your plea. And then here again, this client his guideline range was life in prison for a financial crime with no history. And we were able to negotiate that these were the only enhancements that would be recommended. The judge very likely following the enhancements will be stuck to these. So we're saving, this will essentially likely have saved my client, will result in about 78 months in prison, which is still a lot, but if you want to practice federal criminal defense, you need to get used to that. This is not state court. Still try your best to not get out of prison, but it is the norm, as opposed to facing life in prison. So sentencing, I'm going to talk about the basics. It's something that could be a 5-day presentation, a CLE in and of itself. When you're dealing with sentencing, you're dealing with two different things. You're dealing with the sentencing code, which is the statute, and which lays out the maximum penalties and if there's any mandatory minimum penalties. So again, you're trying to negotiate pleas to charges that have the least maximum and don't have mandatory minimums. And you're dealing with the code, and we'll talk about the 3553 factors, and then you're also dealing with the sentencing guidelines. It's very, very different than state court. Because most importantly, you're lacking that certainty. The client is trusting you and they're pleading guilty. In every plea, and keep in mind as well, in federal court, they are becoming a convicted felon if it's a felony. There's no withhold of adjudications that some state courts have. It's going to be a conviction. So, and they don't know what that sentence is going to be. As you develop your expertise, and if knowing the judge, practicing, reviewing, definitely reviewing prior sentences on similar cases, talking to colleagues, that you can get a better idea and you can make very educated estimates of what the sentence can be. But it's still a complete unknown when you're getting to sentencing. That's why we try and lock in those enhancements as much as possible. The way it works, basically an overview of federal sentencing is after you plead guilty, usually within a day or two, you're going to be assigned a United States probation officer. And what that United States probation officer is going to do is they're going to do something that we call, as an acronym, a PSR. It's similar to state court. They're just rare in state court, and they're often waived in state court. But it's a pre-sentence interview, and then ultimately resulting in a pre-sentence report. Every single case, every felony, which is a majority of federal crimes, great majority, and the ones you'll be dealing with, the client is entitled to a PSR. They can waive it, but there's never really good cause to do so on a felony. The PSR will start with the interview. You want to prepare extensively for that. The judge will set, or if the magistrate takes the plea with your client's permission, the judge or the magistrate will set, at least in the Southern District and in most courts, at least 70 days to give probation the time to complete the pre-sentence interview and the report. The PSR is absolutely crucial in federal. It's one of the by far most crucial aspects of a federal sentencing. It's the one guaranteed thing that the judge is required to review to determine the sentence. Usually they get three things. They get the PSR, defense's sentencing memorandum, which even if the judge doesn't require it, check your local rules, should always, absolutely always be drafted and submitted and put in a ton of work into it. Your client's life could depend on it and their freedom. And the prosecutor might also do a sentencing memo, but they don't always don't. It depends on the nature of the case and how complex and serious it is. So the federal pre-sentence report is so crucial for two main reasons. It is definitely what's most heavily relied on by a judge in imposing sentence. Other than what the judge knows from the guilty plea, which of course they've reviewed, they don't know a background of the client. Most divisions, most districts, and you want to consult your local rules, will give you an hour for sentencing. In the Southern District of Florida, for example, if you want more than an hour, you have to make a motion for why you should be entitled to more than an hour. So you have a very limited picture to present your client as a human being, their entire life, not only the conduct here and the relevant conduct to this case, but all of the potential mitigations and reasons for reductions in their sentence. It all has to be presented in a relatively small package. So the PSR is crucial, and you have to, just like for the proffer, you have to walk your client, spend several hours preparing the client for that interview. You cannot have the client you should definitely be there. Always be next to your client when they have their pre-sentence interview, but also have them know what to expect. It's also an extremely important part of the federal sentencing process because the Federal Bureau of Prisons, assuming your client is sentenced to prison, that is what they rely on when they're making designations. What prison should your client go to? And that is up to the Bureau of Prisons. A judge in federal court, just like in state court, can make a recommendation. You should always ask based on your research and researching programs, client being eligible for a certain program, the First Step Act, which is new, know that. It created a lot of new programs. Know about RDAP, Residential Drug Abuse Program. A lot of times they want to be close to home. Always make the recommendation and give reasons where they should be. At the end of the day, the PSR is going to go to the Bureau of Prisons, and they're going to use that to determine what level of security facility your client should be in and any other needs and matters that are important to their length of incarceration. Should they be released to a halfway house at the end, which is very common in federal court, and Federal Bureau of Prison sentences, which is when they're basically living in a re-entry house with a curfew? And if so, how much time? The PSR is crucial. Prepare them for the kind of questions that will be asked. Okay. The PSR is crucial because the probation officer does also take all of the facts that is provided to the probation officer who's conducting it by the government, by the federal prosecutor, and anything that the defense decides to provide them, and they'll calculate their own United States sentencing guideline range. And that's what the judge reads first. And the judge defers to probation very commonly on what the appropriate guideline calculation should be. So PSR is crucial. Very often, not in all districts, but very often the U.S. probation officer will reach out, and if they don't reach out themselves, you should ask them for what's called a USPO worksheet. It's a worksheet that basically gives you all the instructions of what to have your client bring with him to the pre-sentence interview, if he's able. If he's not in custody, then we have to facilitate other means. But if he's able to, the worksheet does a lot of probation's job for them. and it's always good to make them do less work. That's how probation is. And they have a lot of people they're monitoring. So if they give you a worksheet, the worksheet it's a report. Have it, answer whatever questions are on there. Have it neatly typed out. They'll ask for a birth certificate. They'll ask for many different kinds of financial statements, income tax returns, proof of property, school records. They ask for a lot of documents, and you want to start this process early. So by the time you have the interview, remember the U.S. attorney, or if it's a DOJ trial attorney, whoever it might be, they will have given what's called a prosecutorial memo to the probation officer. It is not the factual basis, which is usually nice and the least damning document which accompanied the plea. It's a memo. The PSR will ask about educational, vocational, special skills, employment record, financial condition. Very important that you also provide any mental health or physical health records to probation, because those do become important for sentencing, and it's important for them to know if they're favorable for your client, because that, of course, does affect sentencing in many ways. So definitely spend a lot of time preparing for the PSR, and it's really the first stage of mitigation. And if you start early enough, it can help you with your sentencing memo as well. You do have an opportunity within usually 35 days before the sentencing. You get an initial draft of the PSR. You have an opportunity to object to anything, either factual or legal objections that you disagree with in the PSR, and you can work it out with the prosecutor in probation. Those objections in that initial draft do not go to the judge. You can see if you can resolve them. If they can't be resolved, your factual or legal objections, then at the start of the sentencing hearing, they'll be resolved with the judge. So be prepared to argue your objections, because the judge will get a final draft of the PSR with any outstanding objections within 14 days. So sentencing hearing itself, definitely you need to get to know your client. You need to humanize your client. Sentencing memorandum is absolutely crucial. Get creative at sentencing. Character letters are fantastic. If you need example of a character letter guide that I use, I've drafted one. I'd be happy to send it to you, that I send to individuals who might be willing to write letters. You can call witnesses, but in fiscal year 2021, keep in mind that 98.3% of all defendants, in the federal system pled guilty. So there's a lot of sentencings, sentencing guidelines, you want to be familiar with the guidelines. They're a guide, however, they're advisory. You definitely want to know them. You want to know the enhancements. I'm going to share my screen here for a moment to go through them with you. So this is guidelines.ussc.gov. It's known as USSC Mobile. USSC stands for United States Sentencing Commission. And everything you need is in here. The guidelines are extensive, but everything you need is here. For example, frequently used table, loss table, huge part of any financial crime. These are the points that are added to a guideline range for financial crime. So very important to get there, and to get there quickly. The sentencing table, of course, this is what a lot of this, really what everything in the guidelines comes down to. So when you're calculating a guideline score or predicting what a guideline score might be, most serious is 43, that's life, First, you start with a base offense level. Each charge has associated with it, and it's in the guidelines, a base offense level. Depending on the type of charge, it can be more or it can be less. Then there's specific offense characteristics. Was it a violation, or what did you defraud a financial institution? Were there more than 10 victims? Were you a minor participant? Were you a major participant or a supervisor? all these different kinds of enhancements that are in the guidelines that you need to be familiar with because they might apply to your case. And they do apply to a lot of cases. Was the firearm used capable of having a magazine of 15 to 21 rounds? These are all things that can add points. There's also a lot of grounds for departure in here. Ultimately, after you've calculated the base offense level, the specific offense characteristics, any potential adjustments such as role, acceptance of responsibility, and then any grounds that you might have for departure, which are clearly listed in the guidelines, you're going to end up with the total offense level. That's going to put you at a number, and on that number, let me see if I can zoom in a bit. But this number that ends up being the total offense level is going to correlate to what the guideline range is in your case. The bottom being, let's say you're at a level 26, bottom of the guidelines is 63, top of the guidelines is 78 if you're a criminal history category 1. Guidelines are the first step in a federal sentencing. Okay, you start with the guidelines. Guidelines under a case called Booker, which you definitely want to be familiar with, are advisory. Are they treated as advisory by judges? Not so much. Okay, so be prepared and prepare your client that there's likely going to be a guideline sentence, but fight like hell to get below the guidelines. Judge could also go up. The judge is not bound by the guidelines either. Okay, they are advisory. They're one aspect of what a judge has to consider, and the judge has to consider it. It's not mandatory the judge follows them. What is mandatory that a judge follows is 18 U.S.C. 3553A. Okay, it is crucial, the crucial statute. Now, this is part of the sentencing code. Okay, guideline range is only one of the factors that under 3553 must be considered by a judge. The other factors, and this is where the sentencing memo comes in, the circumstances and nature of the particular offense. Was it a crime of violence? Are there mitigating circumstances? Was it limited in time? Okay. Defendant's personal characteristics and history. This one is critical. In a complex conspiracy case, a white-collar case, if your client's wrapped up in a conspiracy, what's his level of education? Was he there just pushing paper? Did he graduate high school? Should he be held to the same as the masterminds behind the operation? These are really important things to argue. Employment record, mental health certainly is a big one in many different ways. Was the person abused, subject to drugs at a young age? You really want to humanize your client. The necessity of avoiding unwarranted differences among sentences for similarly situated defendants. You want to be able, when you go to sentencing, to say, Judge, you have previously sentenced a client who did the same thing as my client, same criminal history category, same adjustments. You gave him a variance or maybe a guidelines departure. My client deserves one as well because they're similar. Part of this whole thing of the sentencing scheme is to avoid disparity. The societal need for the sentence imposed, deterrence, specific deterrence, which is deterring your client, our client, from reoffending, and general deterrence, which is deterring society from committing a similar crime because they can see what someone can be punished. General deterrence is a big problem for defense attorneys. We want to keep it towards specific deterrence. Okay, the kinds of sentencing available. When you review the guidelines, it would take me hours to go through all of it today. When you review them, go to the United States Commission website. Okay, they have primers on all of these things. If you review the primers on the United States Commission Sentencing website, USSC, you're going to be in really good shape with enough of an understanding to start federal defense. So the kind of sentences available: can a person be on probation? Is there an alternative? Is there home confinement? Is electronic monitoring impossible? Is providing restitution to any victims is another. Is restitution more outweigh incarceration? And then any policy statements and guide by the Sentencing Commission issued from the guidelines. You can argue all of the 3553 factors to get a variance, okay? A variance. A variance is different than a departure. The difference being that a departure is specifically listed under the guidelines under a certain letter, number, and category as a reason for the judge to depart from a guideline sentence, not a reason to vary based on the 3553 factors, but a reason under the guidelines that the guidelines might not apply in your case. Most common departure, the one that we're going for all along, is something called a 5K1 departure. That's called a substantial assistance motion. If your client has proffered successfully and your client has led, they're very hard to get, so don't be tricked into thinking that you're going to get one even if your client did great. But if your client has led to new investigations, has testified, has cooperated, a 5K1 motion, which is a motion the government files, is the best form of departure. It results in the largest amount traditionally. It's the most common. It's also known as a Rule 35 if it happens after the sentencing, 5K before. But no matter what the guidelines are, the judge has ultimate discretion to reject any departures, to reject any variances, give what the judge feels is appropriate after considering the guidelines and the sentencing factors and the arguments that were made by the parties. So hopefully you have a successful sentencing hearing and you've gotten a reasonable sentence or a great sentence. You've called the right witnesses. You've submitted a fantastic sentencing memo. Get really creative with your sentencing memo. Find out if the judge is a visual judge. You could do a day in the life video. I do that all the time. Follow my client or hire someone to just take a video of my client, interview the client. Just present a real humanization of the client that relates to your specific goal for why you want a variance. So read the primers that are offered by the Sentencing Commission themselves because they're the ones who created them. And just fight really hard, get creative with your sentencing memos. The judges see them all day. They want to be impressed. If it's just a boilerplate, if it's just standard, my client did charity, that's great. But if your client did charity, take a video of them doing charity. Fight really hard for your client. And as far as post-conviction goes, we're not going to have time for it here. That's kind of another matter. But there are a lot of appellate options that are available to your client. What I recommend as a tip is to just make sure that after sentencing, if your client has been sentenced, that they're aware of their appellate options and that they should consult an attorney if you have not entered an appearance for them for any post-conviction matters. So I hope you enjoyed the presentation today. A lot to pack in. This could have been a 20-day CLE. You'll have our contact information here, and it's on the slide, and you can reach out to our firm at any time. Thank you all for attending.